Good evening, everyone. Attorney Matthew Timpanic here from Timpanic Law discussing the stunning verdict today in Massachusetts. Um, what I can tell you is this: when I first saw this case, I definitely think it was a bit overcharged. What I can tell you is, having worked as a law clerk in Massachusetts, being from there, going to law school, some of the counties tend to overcharge defendants. Plymouth County is notorious for it on murder cases. Sometimes what they'll do is, if there's any kind of homicide case, all they do is literally just charge first degree murder. That's it. And then they allow the jury to decide from there. The thinking being is that they can make the argument for first degree murder, and what a jury does is up to them. So when hearing the facts and evidence, it is pretty. The facts were pretty egregious. Um, what I think him taking the stand did make somewhat of a difference. It's usually a huge risk because um, a lot of people try to talk their way out of it on the stand and try to say that, it didn't happen that way and it was just an accident. I definitely think him taking the stand, and more importantly, I think being intoxicated played a role into it. So, voluntary intoxication is not really a defense to murder. It negates mens rea, but you can't really be like, oh well, I shouldn't be convicted of murder because I was drunk at the time. Doesn't work like that. But for me, the biggest aggravating factor was the fact that the defendant took rocks and put him so that his wife's body would get weighed down and dropped to the bottom of the ocean. I mean, well, in the pond. Um, and so that to me, that shows consciousness of guilt, instead of being like, oh my God, it's an accident. But at the same time, it's like, oh, I went too far. Do I think it was first degree murder? Maybe an argument could be made. That's a real tough thing for me to overcome. But I was pretty shocked they didn't get at least second degree murder. But the lesson in this is that no matter what, any real trial attorney will tell you the same thing. You just never know what a jury is going to do. What I found is they do what they think is right. So I definitely think that um, there was no question that he killed her. There was no question that it wasn't just some kind of accident. But it was yeah, I definitely think it's a tough case. It really was. Um, for somebody to be able to get a, get away with 15 to 20 years, that's what I kind of feel like he's going to get. Manslaughter in the Commonwealth of Massachusetts punishable by up to 20 years in prison. The judge's sentence will tell a lot about how the judge viewed the case. So if it was like closer to 5 to 10, because yeah, there's no mandatory prison sentence on this. He could get jail time, probation. That's not going. I don't see that happening. I think the facts show a situation where it's going to probably be in the 15 to 20 year range. If he's lucky, it'll be 10. And get parole after probably half that time. But I think the judge's sentence is going to tell a lot about how he viewed the facts and evidence. And it for me, it's a good example. Um, Kevin Reddington did a phenomenal job, because the difference between second degree murder and manslaughter is probably the biggest difference um, in any kind of charge in terms of sentencing. Yeah, sure, you could get first degree versus second degree, mandatory life or life with parole. Those are pretty standard. But manslaughter, voluntary manslaughter, the judge has a lot of leeway to make the sentence he wants. And even if the defendant was convicted of second degree murder, what often happens is attorneys file like a post conviction relief, asking the judge to mitigate the sentence from second degree murder to voluntary manslaughter. That does happen. Judges in the Commonwealth of Massachusetts have that problem, but that didn't happen. So I think that probably 15 to 20 years is where I see the case. I'm guessing 15. If I were to put an exact number, I'm going to say 15. The reason is when you're convicted of second degree murder, a life sentence in the Commonwealth is viewed as 30 years. That's what they view a life sentence being, where you can get parole, and half of 15 after 30 years is 15 years. So I think if the judge viewed it as a second degree murder case, he's going to give something close to 15 years. I remember when I covered Ashley Benefield last summer, and when she was ultimately convicted of manslaughter with a firearm, I just knew Judge White was going to view this closer to a second-degree murder as opposed to a manslaughter case, and said the same thing kind of with his sentence of 20 years. But 20 years in Florida is a lot different than 20 years in Massachusetts. Massachusetts is far easier parole situations. Florida doesn't have parole. You got to do 85% of your sentence. So, yeah, I'd be tough pressed to think that the defendant's not going to get 15 to 20. That's what I don't know if he was crying because he was relieved that he only got convicted of manslaughter, or if he was just stunned he got convicted at all. Hopefully it's not that, like, Johnny Cochran couldn't even get that guy acquitted, or even voluntary manslaughter is literally almost as good as a not guilty with those facts and circumstances. That kid, that there was nothing good about that case. That the aggravation, the fact that he was able to convince the jury that he clearly wasn't in his right mind, that he's drunk, maybe she was a primary guesser or something like that, that to get that sentence. So he's whatever. If he gets 20 years, it's still better than getting life, because you survive, you get out, as opposed to life. Because what happens, I don't know if some of you remember, about, I want to say 10, 15 years ago, there were issues with the parole system in Massachusetts. People were getting out and then they were committing worse offenses. And so for a while, nobody was getting out on parole. Nobody. Because I remember the firm I was working at the time did a first degree murder case in Brockton, which is where all criminal cases are done in Plymouth County. They, of course, like I said, charged him with first degree murder. It probably wasn't. It's probably closer to second. That's what he ultimately got convicted of. And so it's kind of, yeah, along those lines. And he got life, and I think he's up for parole in a few years. So that's the thinking being, as my boss at the time was trying to get the guy manslaughter, because that's only punishable by 20 years. And even if you get 20 years, you get out of prison. You survive, you get out. That's the way it works. So it was a pretty stunning event. I can't even talk Lori Vallow, because I can't deal with that level of narcissism, that level of just being removed from reality. It's unlike anything I possibly have ever seen. I'm trying to think of people like that, defendants over the years that I've covered. Rittenhouse, Rittenhouse covered, and the Abed Arbery case, which I did for Law and Crime. I have never seen anything like Lori Vallow. And I remember being on doing an appearance on Law and Crime, and one of the hosts, who remained nameless, was like, I'm so done with this case. I was like, yeah, I don't want to talk about it anymore. And I told the producers, like, I'm not going to appear again and talk about this case. So that's the extent of what I'm going to talk about Lori Vallow, because if you want to go watch somebody do that, basically try to gaslight the jury and just totally misrepresent facts, it's like, oh, okay, I'm just having fun. I'm already doing a life sentence, so what does it matter? That's kind of what it felt like. Oh yeah, Darrell Brooks. Darrell Brooks is a sovereign citizen. So I have both prosecuted and defended sovereign citizens, such as Darrell Brooks and the Christmas Day or July 4th massacre. I forget which one it was, New Year's Day or something like that. And sovereign citizens, they cannot understand. They truly and honestly, I actually think it's more of a mental illness. They think the laws of the United States don't apply to them legitimately. Like, they will say, when you're in court, it's always a trial, and they'll be talking about, talk to the judge when the judge's trying to talk to them. Are you the trustee of this account? And they start talking about the corporation. I prosecuted a guy in a DUI case who was a sovereign citizen, and he did his closing on fake American history, like fake history. And he had his name, what we'd call him in court, his legal name, he would say it's his slave name. So we had to call him by whatever name that he decided, because otherwise, if you said his slave name, which wasn't a slave name, it was just his legal name, he would interrupt and then correct. So I would just call him by the other name because then he didn't interrupt. So yeah, those are I did what 3 or 4 sovereign citizen trials, and then I represented a guy who on a murder case in a sovereign citizen, and they're just removed from reality. It's really it's pretty awful to watch. Um, yeah, and it's not good, and it just doesn't it our judicial system takes a real hit because jurors sit there and they have to listen to this, and sometimes it's months on end, weeks, months on end, and it's like I'm missing work for this. So when they go back there, it takes them not even an hour to deliberate, and it's just like with Larry Vowell's case, it's going to take them 2-3 hours to convict her, honestly. So I definitely think that the doctor got as good of a result as you humanly can get, and sometimes that's what you have to do when you're a criminal defense attorney. The state is offering, or the Commonwealth, depending on which state you're in, are offering this kind of deal, and it's like we're not budging off this, and it's like all right, fine, we'll just go to trial and mitigate it. And unfortunately, a lot of prosecutors, almost all of them, when you get to that level of doing those types of cases, homicide cases, they've never been anything but prosecutors. So they don't know how to understand. They look at it, it's like, oh, how could they not find first degree murder or second degree murder? I'm like, well, take a look at it and see. Because if they were smart, they probably could have gotten away with um, maybe offered second, or more likely got away with, you know, maybe manslaughter, because a manslaughter verdict is not going to look good. That's it's a win, but it's a real soft win. I've told you the story. There was a prosecutor at my office who would watch on the screen when a verdict would come down, and it'd be whatever the charge is, as long as it was a felony. She's like, well, at least it's a felony. And it's like, that's not really what it's all about. It's convicting people and trying people for charges that are justified. Which brings me to the Karen Reed case. So right now, I think I saw that they have 8 men, 8 women, so 16 jurors, and they're kind of holding out for more, which tells me that they're seeing the people coming in, they get impaneled, and then they get bounced off the jury. And that's it's not a situation where you're trying to find people who are going to be able to sit and listen to your case, because it's going to be probably 6 to 8 week trial. So the first thing you don't want on your panel is people who have jobs that don't pay them money, or who aren't pay them. They're like, oh, well, we'll keep your job, because that's a hardship. And so when people, especially when kind of a recession and seeing the market going down and everything, if the job they have is not paying them to be there, that's something they're going to be dipping into their savings, trying to live on one income for even 6 to 8 weeks. And that's a long time. So when you go back into a jury room and you're looking at a case and you're like, oh, well, I'm not finding second degree murder because of the investigation, I think Michael Proctor is disgusting. All of that is part of the reason I think the Commonwealth brought in Hank Brennan, because he's been on the other side his entire career. And only a defense attorney is going to be able to look at the shortcomings of the case and be able to probably combat them and be able to prepare for them. Because Adam Lally, I believe, has only ever been a prosecutor. He did a commendable job. But there were times when he walked right into Alan Jackson backhanding him in court. And the jury, definitely the whole Proctor testimony and the Sally Port videos inverted, the jury just really wasn't ready for it. So when their jaws dropped, that was kind of like, that was not a great moment. But a defense attorney who's done this and prosecuted, and defended high profile cases like Hank Brennan has, like, all right, this is where they're going to focus in on their case. This is where they're going to make their stand, because that's all they got. They need to be able to hammer the evidence. There's got to be some evidence somewhere that they want to try to hammer to create reasonable doubt. They need to manufacture it. It's not going to come for the conspiracy. They know that it didn't work in the first trial, and that was their best chance. It's certainly not going to work here. So you need to be able to hammer reasonable doubt on the investigation, that the information that was provided, that is testified to, can't it has to be taken with a grain of salt. I'm worried that there are many biased people among who have been seated. That's why they're excluding. There, every time I see kind of like Christina Rex or Ted Daniels talk about the people, and it's something like 90% of people have heard about the case. That's not really uncommon for something like this, but it's more about formed an opinion because this case has become so big that every single person is like in the Commonwealth just about has formed an opinion, thought about it. It's around the clock news. So it's definitely difficult to find people who are going to come in with an open mind and want to make sure yeah, people will get sick. So it is going to be that's why they're trying so hard to get this right because you don't want a situation where, because if you go under 12 jurors, you can't convict. That's a mistrial. So if somebody has surgery, somebody realizes that they can't do this, you need as many alternates as you can because I can tell you Judge Canonen does not want to do this for a third time. That's been made very clear by her, some of her rulings where she's erring on the side of, I'm just going to let this in and allow the jury just so that it doesn't create an appellate issue. If you're convicted, you're still going to appeal, but you're going to have no real avenues and grounds that are going to be successful. I haven't seen, to this point, a real valid appellate issue that could lead to the case being overturned. And not even allowing Aiden Kearney's attorney to serve on that was not going to be an appellate issue. I don't think that was going to work just simply because it's a real conflict of interest. And I don't even think with an informed consent, you'd be able to get over that waiver because they're too ingrained with each other. So when I think I said that I was going to do kind of like a defense opening statement. How many murder trials have you been a part of? Several. I worked on my first murder trial when I was 22, 23. It was 2014, the first case I worked on. I still have it was when I was working at a defense firm, and I still have the autopsy photo from the victim ingrained in my brain forever. There are some things that you just can't unsee. And I've also defended personally people charged with murder as well. So the answer is several. I can definitely tell you that for my opening statement for the defense, you hammer the reasonable doubt. You don't come off with the conspiracy. You don't want to do that. That's intrigue. That's trying to create a situation that is going to come off a little desperate because Hank Brennan's going to just be hammer facts evidence. It's going to be bang, bang, bang. And he's not going to talk about glasses and where they were manufactured and stuff like that. He's just going to hammer facts. So you also, as a defense attorney, need to hammer fact. Fact. All of these individuals heard the defendant say, I hit him, I hit him, hit him. None of those individuals wrote that down. That's first and foremost. It's like, okay, then you go to talk about, it's like, all right, on the day in question, talking about how they use red Solo cups to pick up blood and they have stop and shop bags. That shows kind of the how very simple and just not scientific the investigation was. So if it starts bad, it probably continues bad. So you want to show that it's like this was just the beginning of a horrific investigation. This is what it should be. I don't know if Alan Jackson's going to go that direction because he wants the jury thinking in his mind about that conspiracy for the entirety of the case. And I've said from the very beginning, even before the first trial, I say hammer reasonable doubt through the investigation. If people can't trust what was coming out of the investigation, then they can't necessarily trust what the results were. And unfortunately for them is that they're too deep into the conspiracy to be able to do that. So when they're trying to hammer what should be the very simple, easiest way, it's like to be able to get an acquittal. Don't waste it doing stuff that are easily debunked. Don't You can show inconsistencies like with don't go with the butt dials and like 227. How long did that was debunked in the first case? You can try to bring it in, but the first jury didn't buy it. They didn't, and this one isn't going to buy it either. They're going to be like, oh, well, this investigation was started bad, it was compromised, and look at the individual doing it. Um, so, do you feel that the defense lawyers are more concerned this time around, more worried? Okay, this is an observation I have made, that it, because I remember in the first trial, Alan Jackson and David Yenny would come in almost like skipping in, strutting in, like owning the courtroom, like they did throughout the pretrial hearings. I don't feel that same confidence this time around. I don't know if something's new. Definitely the gag order plays into it, that they can't go up and just play with the media this time around. That the only person who gets to talk to the media is the defendant, as she's pretty much giving updates um, on the juror situations. But even when I see them in pictures and video, they don't look confident. And even I remember watching the Body in the Snow documentary, where David Yannetti doesn't clearly look like he's buying the conspiracy himself. Look, Alan Jackson either believes it or he's been able to convince himself to sell it. David Yannetti couldn't do that, and that was pretty clear in it. And Elizabeth Little kind of is up in the air on it, but just enough where she could say it with a straight face to um, for Alan Jackson to be like, "Yeah, I agree with it." I think they have a good faith basis to make it in their head. Otherwise, it'd be an ethical issue. But as we saw with Judge Cannon's ruling with excluding Colin Albert as a third party culprit, I don't see a situation where the judge doesn't believe it whatsoever. But should be worried. Yeah. It's definitely so when you think of what else they're going to hammer home, it's Alan Jackson needs to keep it on the facts. The investigation, fact. Michael Proctor, fired, terminated. His investigation, he was compromised. He should have excluded himself. He's sending the unprofessional nature of the investigation, no nudes, like, oh, talking about her MS and like providing details because it is true. The moment he showed up on the scene, he probably should have recused himself. So that's where I keep going with that. I don't know if you go with the inverted Sally port video. That's just more intrigue and everything. But I would just hammer home the investigation because I would allow, if you really want to go the conspiracy element again, if you really want to try that, you don't do it during your opening. It looks desperate and it looks like you got nothing. You allow it to show up and kind of develop itself in the evidence, and then you can be able to argue it in closing. Remember, opening and closings are two completely different things. Openings are about facts. Closings are about arguments. Very simply, you can't argue during opening. You can't. You're just about to lay out what the facts and evidence says. So your opening, just lay out what you know the evidence is going to show. Do not try to argue this conspiracy or even try to lay that foundation. This case comes down to reasonable doubt. That's it. Yes and no. It's about whether it's going to be proven. For me, the second degree murder case is what the evidence I want to see, that how they're actually going to make that in this case. I kind of saw in the first trial the argument they're making, but it was not flushed out at all. It was not explained even to me, or I knew what they were trying to say. And if I'm not doing it and I do this for a living, people who are just from the community who aren't lawyers are certainly not going to understand it. So it's going to be an interesting trial to see. It's going to be a lot more of a fair fight if it were, because Hank Brennan is in the top 1% of all trial lawyers in the country. Kevin Reddington is in that same category. Jay Carney is in that same category. So you got one of the best trial lawyers in the state and in the country, for that matter, going up against the defendant's dream team. So it is going to be an interesting case. I For me, I want to see, I want it everything just laid out very simply, because they did a half decent job. Like the evidence could have been there, but it just wasn't explained, and they definitely didn't do the best job picking the jury in the first trial. Yeah, there is going to be more evidence, and there's going to be more, and then the experts, the dog, the Commonwealth's calling their own dog bite expert, James Crosby, so to kind of counter what the defense is going to say, or I don't know if he's going to be called in rebuttal. I think that's most likely the scenario, or they might just get out in front of it during the case in chief and being like, no, it's not this. So you kind of take out all the air. So that might be the strategy for Hank Brennan. Just take out all of their avenues in your case in chief so that when they go up there, it just sounds ridiculous. And the whole thing. Am I crazy if the evidence is just damning? Maybe she should take the stand, claim it was an accident, doesn't remember to save herself from second degree. What I can tell you is this. You The only time a defendant, so make this very clear, uh, it is the defendant's decision alone to take the stand. The attorney can say whatever he wants, he can do it, but he can't prevent the client from taking the stand. That said, it's almost always a mistake. That was what was so shocking about this mass case, the doctor killing his wife, because he was took the stand and kind of almost explained it away. And I can tell you that that happens maybe 2 to 3% of the time, if that, or the defendant takes the stand and explains it away, because they get caught in a lie, their stories don't make sense, and it definitely, it usually just doesn't work. So I don't know if her taking the stand, um, I don't, because if they think that they could get her to walk, they're not going to put her in a situation to go for a full not guilty. I think that's too much for risk, especially if she only gets convicted for vehicular manslaughter while under the influence. Um, but yeah, so it is the reverse speed. That's the evidence. That's what, as I saw, what the only thing they have for second degree murder, because the phone calls don't really show malice, and they don't really make the murder case. It's the vehicle data. The vehicle data does not improve. It's not going to result in a conviction for second degree murder. It's just not. And it would have to be overwhelming to get that second degree murder, where the jury's like, we don't have a choice in the matter. It's like, that's what the evidence says. I just feel that if it's going to be if it's going to be, I feel the jury is just going to give the defendant the benefit of the doubt. But that's if they prove their case. They don't, the defendant should walk. That's the system. Um, yeah, I have a hard time thinking the defendant will actually take the stand. She likes being able to speak to and not be really cross-examined by people who aren't asking her softball questions, who aren't going to. So I just don't think it is. Um, I do believe it costs $5 million for her defense. Other attorneys have opined on the same thing. You have 3 attorneys working around the clock. Because remember, when on these types of cases, they're billing 12, 14, 16 hours a day. Now, 18, 6 to 8 week trial, think of all the motion hearings. And if they're coming off at $500 an hour, you do the math. That runs up real quickly. And this has been going on for 3 years. So it is like, it's going to be, I am anxious to see how they are going to approach the case differently this time around, because Hank Brennan's not really given any kind of indication of what they're going to do. I guess on length of trial, I'm going to say 8 weeks. I think that there's going to be a lot of objections this time around, like there was in the first trial. I can tell you that um, I am not a huge sidebar person at all, and that just slows down a trial. And when defense attorneys and um, they do sidebars, it's entirely intended to, most times, to disrupt the flow of the presentation and get the jury forgetting about what they were hearing. I remember I covered the Curtis Reeves trial with Jesse Weber on Law and Crime pretty extensively, and that was like abusive. That kind of just sidebars, and it's like it's an objection, noted, overruled, sustained. You need a sidebar if it's something a huge issue that you need to say outside the presence of the jury. Um, so that's definitely where it's at. I can tell you that they're going to start openings on Tuesday. So impaneling is going to be done on Monday. That's the expectation. I would probably say probably 2-3 hours for opening for each side, maybe a bit more, because you want your opening to you. And this is what I've said previously. I think we're going to end somewhere around this. You want the jury to think after your opening, they want I want to hear more. You don't want them to be like, oh, when are you going to sit down? So say what you need to and sit down. Allow the defense or the other side, what it is, to be the one talking relentlessly and being like, you're just going around in circles. I want to say it was Napoleon. Never interrupt your enemy when they're making a mistake. A long opening statement is a mistake because the jury is at some point they're losing their attention. Like, can we just go on to hearing from people? We don't want to hear from you. Then they think it's some kind of big vanity exercise. And then the jury's already has kind of a not so great opinion of you because you're asking them to agree with you. And you want, there are instructions that say you can't hold it against the attorneys if you don't like them, but they're going to listen more attentively for detail if you're doing a good job and you keep their attention. So I think Monday we'll have an impanelment, and I think Tuesday we'll have the next show. So talking about what I thought on about the opening statements, the jury panel, and kind of give a synopsis. I'm not going to do one of those situations where I play something and then talk over the person. That's never going to be me. There's plenty of people who do that. But for now, I think that it's going to be very interesting to hear the jury and panel and the opening statements. And I'll see you next Tuesday. Have a great weekend, everyone.